Hey everyone, Scott Fine, founder of Joey's Legacy. Today's guest is attorney Alexa Carreno from Environmental and Animal Defense Law. I'm sorry, I messed that up. Did I say that right?
Environmental and animal defense.
Okay, my apologies. Denver, Colorado. And Alexa's going to spend a little time with us today, answer some questions, and hopefully give you some education in the area of veterinary malpractice. And at the end, we'll ask her to provide her contact information in case any of you want to contact her. So hello, Alexa. How are you?
Hi, good. So good to meet you. So good to be here.
Likewise. Thank you so much. So run us through the average, if there's such a thing, uh, veterinary malpractice case. So let's say one of our members brings an opinion letter to you, obviously a Colorado resident. What's your first move, and how does the case progress, generally speaking?
Yeah, so usually when we encounter folks who are looking for legal representation for veterinary malpractice, they usually start by calling us and explaining what went wrong. And from there, we have a consultation call with them, sort of go over whatever documentation they may already have, such as veterinary records, emails, communications. If they already have an opinion letter drafted up from an expert, say through your organization, we review that as well, and then recommend based on their scenario what would be the best path moving forward. And for most folks, that looks like sending out a legal demand letter, setting forth all of the claims that we believe that they have against a veterinary provider, and then sending that to the veterinary clinic. From there, it's usually given over to the insurance company, and then we resume communications with an insurance adjuster and try to negotiate a settlement. If settlement fails, we then explore with clients what may be the appropriate next step. That could look like reporting to the state licensing board. It could look like moving forward to litigation. But as far as those initial steps, it's usually that consultation, in-depth conversation with the client, and then moving forward with sending a communication to the veterinarian's office.
A lot of the people that we assist are just so anxious to file a complaint with the vet boards, and I presume your experience with vet boards is the same as most of the rest of us. They're more interested in protecting their own than in doling out justice. I don't want to put words in your mouth. Would you agree?
I would say that it's, in my experience, been pretty difficult to get a positive outcome from filing complaints with the state veterinary board. However, most clients that we deal with want that sense of justice and want a practice to be disciplined. And I tell them that if that they are interested in some sort of discipline against the veterinarian, some sort of continuing education, for example, or suspension of a license, going through the state veterinary board is going to be the route to take for that, as opposed to litigation or settlement negotiations with the demand letter. That's going to cover the monetary side of things.
Okay, so is it a fair statement that a plaintiff should want to dispose of the legal side of things before the vet board comes back with their decision? Because in the majority of cases, vet board is not going to find any kind of serious violations, even though there may very well be, as our vets find. And so my question is, isn't it better to dispose of the case from the legal side first? And then if the vet board comes back and says no findings, it's kind of too late for the bad actor to do anything, rather than the vet board rendering an opinion which is in favor of the bad actor, and then all the bad actor has to say to the judge, why are they suing me, judge? Vet board said I didn't do anything wrong. So
Yeah. I
Would,
can understand that sort of balance, and that's definitely a case-specific recommendation
yeah,
based on each individual client. So, for example, if there is something that may be egregiously wrong, say you bring your dog in for a nail clipping and their leg gets amputated. I'm making up an extreme example here. That might be something that very obviously the vet board can see something is wrong, you would hope. And having a veterinary board opinion that is in your favor certainly can help the evidence that you have to put forth before the judge in the litigation itself. Now, if it's something more nuanced that may be not very strongly supported by an expert opinion letter to begin with, more so sort of like a nuanced issue of care that a veterinarian could go either way depending on their position of what's reasonable. If there's a higher risk of predicting that maybe the state vet board comes out in the veterinarian's favor, certainly that's not going to be helpful in litigation. So
yeah.
it's something that is very highly considered, but also a little bit unpredictable because, as I just mentioned, veterinarians all have different expectations of what they think is reasonable, that all kind of meld together for this baseline that you then later have to put before a judge and jury.
Let me go back for a minute to what you were talking about a little while ago regarding writing a strong demand letter to initiate the action. So what would you say roughly percentage of times that the demand letter will lead to an out-of-court settlement?
So I think it's difficult to put in terms of percentages generally, but in my experience, I would say that more often than not, a strong demand letter can result in an out of court settlement. And that's especially true when supported by a very strong expert opinion letter. So with veterinary malpractice cases, I'm sure, as you know, as some of your followers are aware of as well, it's not just the law. It also really heavily depends on that expert veterinarian that your attorney, that myself, is going to be working with, in order to really advance a client's position in showing that something has gone wrong. So when paired with a really strong demand letter in terms of the legalities, as well as a very thorough explanation of the facts of what had gone wrong medically, more often than not, an insurance company is going to look at that and assess it in terms of, hey, let's just try to resolve this without spending more money on legal fees. But at the same time, I've had instances where I've had a strong legal demand letter, I've had a strong and thorough multi-page expert opinion letter, and insurance companies just say, no, we're not going to offer you anything. So in terms of dealing with insurance companies, just like the state vet board, each insurance company is a little bit different in how they like to handle claims that come before them. And that's also unpredictable as well. So, what I like to tell clients is nothing's really a guarantee. I can't guarantee that you're going to get a settlement. I can't guarantee that you're going to win in court. But we can definitely do our best to prepare the strongest evidence and the strongest argument in order to try to get some success for our clients.
So let's take it to the point where you realize, or the insurance company tells you, no, we're not going to offer you anything. And the plaintiff decides to move forward with litigation. From that point until, and again, in your experience, what's the average time from the time you begin to litigate until you get a judge to rule?
To make a decision. I would say that it's difficult to predict because there are so many barriers that can come through in litigation. But when you have what's called a straightforward case without any sort of significant delays by either counsel schedules or without any sort of advanced and prolonged motion work over anything really that could be happening within the pre-litigation process or pre-trial process, excuse me. if it's very straightforward and both attorneys are cooperative and the facts are pretty clear and there aren't any sort of scheduling delays, for example, I would expect that based on my experience, it's about 1.5 years from the time the filing is initiated in the court.
Wow.
So it is pretty long. Yeah. And that is something that we try to prepare our clients for emotionally, because as you know, veterinary malpractice cases are very emotional cases. And it is a significant burden to take on. And we believe it's important for folks to prepare themselves for just how long they're going to have to continue to revisit this traumatic experience for themselves in order to try to seek justice. So we think that by preparing folks ahead of time with that expectation, letting it sit with them a little bit before they make that decision, if they're able to, is the best route to ensure that they're able to keep carrying on and not just get frustrated in the middle of the process and want to take whatever settlement may be offered, even if it's not a very good one.
Okay, let's talk a little bit about what most plaintiffs are energized to do, and that's simply get the bad actor. Okay, and most of them see recovery of veterinary costs and sum of money that they would need for another animal, and recovering cost of cremation, necropsy, pretty much any economic cost that is involved because of the negligence of the bad actor. They're looking for more meat on the bone, so to speak. So, for example, fraud, anything that would add substantial amount to the value of the case. Punitive damages for fraud. How does it work in Colorado in terms of if you can prove fraud, falsifying documents? They bring you two sets of records. This happened to me with Joey in Florida. I went to get his records a week later. They looked like they looked. Everything looked right to me. After I filed with the state of Florida, the records that the vet sent to Florida looked totally different. My attorney said, look at the records that you picked up. They don't look anything like. So we know that vet falsified the records. Okay. I brought it to the attention of the assistant state attorney. She said, well, we already kind of cut a deal with him. I really can't go back and do anything, which it is what it is. I know that goes on all the time. But my question to you is, when you see that kind of thing, falsifying records or any other overt act of fraud, what can you do in the state of Colorado?
Yes, that's a really good question. And in my experience, and I know that people have different experiences without going to attorneys, but just with my practice, I've seen only a handful of people come through the door where records are allegedly falsified. And I can tell you that these are usually the ones that settle outside of court. Insurance companies and veterinarians really don't want to expose themselves to that bad bad publicity or additional liability when that truth comes out. So they're more likely to make a monetary offer that's a little more than what you may see at trial, for example. But it's important to remember that, like all American litigation, the accused parties are not liable until they're proven liable, even in civil litigation. So when you have an instance of records falsification as a potential claim, your expert veterinarian that you're working with not only then has to evaluate the sort of medical care that was given to the animal, but also what is a reasonable practice for record keeping. Is the way that this veterinarian kept records usual? Would it be normal to expect this sort of difference? Is it a more clerical difference, or is it a significant difference in notes? So even though it may be very facially evident to a layperson, these two things do not match up. You're still going to need the expert to go before the judge and the jury to explain, yes, they don't match up, and here's why it's wrong that they don't match up. So in Colorado, you're correct on that inference that punitive damages are available in instances where veterinarians have willfully and wantonly done bad actions throughout litigation or in pre-litigation in terms of falsifying evidence, tampering with evidence. But then there's also a claim possibly under the Colorado Consumer Protection Act, which is in place to protect consumers from bad actions by folks who are providing a service or providing a good. And that includes veterinarians as well.
A lot of the people that come to me when they first call me and I ask them to tell me what happened, they arbitrarily use the word kill. The vet killed my dog. I don't get into it with them, but I always learn that the word kill is an intentional act. So my first response is, well, did your vet really kill your dog, intend to take your dog's life, or did he just cause the death of your dog? I don't get into that with people. You know, they're very emotional, and I just let them say what they want to say. Have you ever come across a case where the veterinarian actually intended to cause the death of the animal? And if so, how was that case disposed of?
I can say, fortunately, I have not had one of those cases come through my door. Most often, it is going to be cases where vets have negligence, and it could be egregious negligence. It could be severe ignorance of how their machinery in their office works, to the point where it may look like they might have had some sort of intention to do something horrible. But in reality, the veterinarians that I've dealt with, even though they've messed up, I could definitely say in all instances, they have never been so ill-hearted to want to actively kill an animal.
Okay. I've seen it a few times in almost 7 years of doing this now. Very rarely, is what you kind of alluded to. But, what people really believe, what they believe, whether it's reality or not. And so I tell them, if you really, really sincerely believe it was an intentional act, I think you need to contact your state attorney's office and see if they'll file charges. Of course, I don't get involved beyond that. All right. Well, tell us a little bit about you, how long you've been an attorney, your firm that which you co-founded, and what other type of animal law do you practice other than veterinary malpractice?
Yeah, so I've been in practice for 6 years, and we've been running our nonprofit for as long, Environmental and Animal Defense. And we like to say that when it comes to protecting animals and the environment, we'll work on it. So we really have a wide variety of cases. We have an abundance of variety in environmental protection cases, which also include, of course, wildlife protection, which falls under that additional umbrella of animal law. But when dealing with companion animals, we represent individuals and we represent families. We represent nonprofits and other rescues. So in that variety that we have with companion animals, it's not just veterinary malpractice. We also handle custody battles, dog bite defense, defense against dogs being improperly impounded, a whole variety of companion animal issues.
So even pet trusts, if someone wants to provide for their animal after they pass, is
So
that
we
something?
actually haven't had someone come to us with a pet trust specifically, but we certainly offer that service and would be happy to put together an estate plan for someone who's very concerned about what will happen to their animal after they pass.
Okay. All right, great. Why don't you tell us how people can contact you?
Yeah, so you can contact us by going to our website at www.eadefense.org, or you can give us a call at 720-722-0336.
Excellent. Okay. I want to thank you for your time today.
Thank you.
I will invite you back soon. I
Great.
appreciate it very much. And I'm sure we'll communicate about cases going forward at some point. So,
Sounds great.
all right, cool. Have a great day and thank you very much.
You too. Thank you.
I will see you next time on Tales of Betrayal. Bye-bye.
Bye-bye.